law scholar, and he has broad academic and professional expertise in a wide range of commercial topics. He is one of the world's leading experts on the law of agency and is general editor of Bowstead and Reynolds on agency law. Peter is a visiting professor at the University of Oxford and a senior research fellow at Harris Manchester College, Oxford. Peter has had a long and illustrious career as an academic at the University of Auckland, where his writing, particularly in company law, has had a profound effect on the development of New Zealand law and on law reform. While still an academic, Peter has also worked in private practice and he's provided his expertise on litigation at all levels of the New Zealand court. Since 2010, Peter has been a door tenant at Fountain Court Chambers in London, where he has provided opinions on litigation at all senior court levels, including for the UK Supreme Court. In 2017, Peter became a full-time barrister at Bankside Chambers in Auckland. But fortunately for the Academy, he has remained a prolific and senior contributor to academic debate. Today, as I mentioned, he will speak on the contentious Quincecare duty, which deals with banks' obligations as mandatories, which is a topic that is, of course, relevant to core banking business. So without further ado, I'm delighted to introduce Peter Watts.
Thank you very much, Helen. That's a very kind introduction. Well, good afternoon, everyone. I gather there may be some people as far away as Perth, and obviously people here in New Zealand as well. I'd start by saying that this material of this talk is not rocket science. It's fairly straightforward in many ways, but obviously, if you haven't read the article on which this talk is based, you'll see that the courts, in my view, have got themselves into a complete mess, particularly in England, on this topic. Some of you listening may be acting for parties suing banks, so I'm not assuming that everyone is a banking lawyer. The general theme of the lecture is in defense of banks, of course, but hopefully those who want to sue banks will get something from it in any event. And as they say, you get what you pay for, and I gather today's seminar is free, so we'll proceed as organised. Right, so the Quincecare duty defined. It's the putative duty is that a bank owes a duty to a customer not to follow the instructions of a person authorised to operate the customer's bank account when it has reasonable grounds for believing that the mandatory is dishonestly using his or her power. The slightly shorter version of this appears in Lady Hale's judgment in what is now the leading UK case Singularis. It is itself only a very slightly reworded version of Mr. Justice Stains's statement of the duty in the original Quincecare case. A bank should refrain from executing an order if and for so long as it was put on inquiry by having reasonable grounds for believing that the order was an attempt to misappropriate funds. In Singularis, the bank argued that if there were a duty, it was one only to inquire of the customer. And in Singularis, there was no one honest to inquire of, since the party misappropriating funds was the sole executive director and sole beneficial shareholder. He was defrauding the creditors of the company. The Supreme Court rejected the argument, saying there can be a duty on a bank not to pay independently of a mere duty on the bank to inquire. I think this holding is particularly indefensible. In other words, it might be easier to justify banks having a duty to inquire if there is somebody to inquire of. But the Supreme Court took no such distinction, and it's now been followed in the Stanford case, which is a more recent English case, postdates my article, which involved a Ponzi scheme where the operators of the company were all dishonest. And the Nigeria case that we'll come to in the English Court of Appeal is really one where it was not easy to work out who the bank would have inquired of also. In other words, the idea that seems to be being placed, or duty that seems to be being placed on banks is one just not to make the payment. But even a mere duty to inquire, in my view, is problematic. Inquire of whom? Duty to stop internet banking while one inquires? And after all, people are only supposed to give authority to operate their bank accounts, including companies, to someone they trust in the first place. So you have to have a truster, somebody to watch the guardians under the theory of the English case law. In Lipkin, Gorman and Karpner, which was one of the progenitors of the Quincecare duty, Lord Justice Parker proffered an even wider test of liability on banks. This has not been ever said to be wrong, and indeed it was cited with approval by the English Court of Appeal in the Singularis case. The question must be whether, if a reasonable and honest banker knew of the relevant facts, he would have considered that there was a serious or real possibility, albeit not amounting to a probability, that its customer might be being defrauded, which is an extremely aggressive duty in my view. Just a possibility, not a probability even. In this talk, I'm generally ignoring the direct effect of statutes such as the Anti-Money Laundering and Countering Financing of Terrorism Act, which we have in New Zealand. There'll be comparable things in Australia, and the Consumer Guarantees Act. I'll say a little bit more about these two types of legislation or about consumers a little bit later on. Now, I want now just to briefly outline the argument that I make against the duty, and then turn in more detail to take us through what I think are the key points, underlying points as to the merits. So whether in contract or tort, we are concerned only with the default rule. What obligations should a bank be taken to assume re a customer's mandatories? I've got a little square brackets here that New Zealand tort law is a bit more aggressive than you would be found now in Australia or in the UK, and doesn't fully accept that tort requires an assumption of responsibility. But I think some of the New Zealand cases do assume that there needs to be an assumption of responsibility. And so I think we should say that we are dealing with only a default rule when it's talking about liability in contract or tort. Customers cannot in justice have it both ways. They cannot expect rapid and unquestioning adherence to the mandatory's instructions, and at the same time, a duty not to act just because a bank has substantial or even strong grounds for suspecting misconduct. Banks are not agents vested with discretionary authority. A bank's sole positive duty is to meet the instructions forthwith. The bank's not appointed to monitor the honesty of those mandatories. A regime where a bank must reject the instructions of a mandatory when all it has are reasonable grounds for doubting the mandatory's honesty compromises the bank's non-discretionary role and undermines the use of banks as a reliable payment mechanism. In my view, a clear rule that triggers liability in the bank only when its participating staff, like the customers, are dishonest is a preferable default rule. The Quincecare duty itself, as I argue in the article, is founded on a misconception. Mr. Justice Steyn, in formulating the duty, which he found wasn't breached on the facts, relied almost entirely not on pre-existing case law, but on bousted on agency. Now, I first got interested in this duty because since 2008, I've been the editor of this long-standing work, and there was nothing said about Quincecare when I took over. And in fact, I really only got onto it recently. So the latest two editions have said something about it, the latest edition a bit more. And he relied on this, well, this is what he said was in Bousted, prima facie, every agent for reward is also bound to exercise reasonable care and skill in carrying out the instructions of his principal. What Bousted actually says, and the wording hasn't changed since Quincecare in the 1990s, it's the same in the current edition, which came out only a few weeks ago actually, is at 6.020, if the agent has a discretion to exercise, he must in general use proper care and skill. So that's what it actually says, if the agent has a discretion. No such duty of care is attached by Bousted to non-discretionary powers, which are dealt with in the current edition at 6003. And again, this wording hasn't changed since Quincecare. Failure to adhere to instructions is by definition a breach of duty, and in principle results in strict liability for resulting loss. And this duty applies to both acts and omissions. So if you do something that doesn't comply with your instructions, that's a breach of this duty. But also, having undertaken to do what you're told, you don't do it, omit to do it, then you'd also be liable. And Bousted says, even if the principal's instructions are foolhardy, the agent must carry out what he has agreed to do. One should note that what Quincecare posits is not merely an implied term to perform promised services carefully, but a new promise, a new service. And so this is really bringing out that this isn't some technical distinction between discretionary powers and non-discretionary powers. It's not technical, it's fundamental. Because if you've got no discretion and the bank's told to make a payment, the only way to make that payment carefully, if you would act carefully, is to actually make it into the correct person. Logically, therefore, what Quincecare involves is a separate duty, not an implication into an existing duty, a separate duty, a minimum one to inquire, and post Singularis, an outright duty not to pay. That said, it's fairly obvious that a junior agent would not need to follow a senior agent's instructions. So the junior agent here is the bank, the senior agent is the mandatory, where the senior agent is acting dishonestly vis-a-vis the principal. The difficult questions are these. Does an agent have a privilege not to follow the senior agent's instruction if the latter is honest, but there are reasonable grounds for fearing dishonesty? To that question, you might want to tag map associates, a case we're going to come to. And B, the second question, does an agent have a duty not to follow instructions if the senior agent is dishonest, but the junior agent has only reasonable grounds for thinking so, but no assurance that they are dishonest? The answer to the two questions should go together. The answers to the two questions should go together. But it does not follow, as Mr. Justice Steyn thought, that the same pair of answers should be applied to all types of agents. One is looking for the appropriate default rule for the type of agency in question. Where the agent's role is truly non-discretionary, in my view, there is no room for a negligence standard. But other agents might be expected to go back to the principal and inquire or not make a payment. And there are cases on the duties of solicitors to check and so on. But so it is always a default rule, and with the bank, it seems to me that it is intended to be a truly non-discretionary obligation that the bank assumes. So if the appropriate default rule is to follow the instructions, unless it actually knows, the bank knows, through rules of attribution, of course, that the mandatory is acting dishonestly, then that is what a reasonable banker should do. In other words, asking, as the cases do, what a reasonable banker would do begs the question. You've got to decide what the default rule is first. And the fact that now, at the moment, banks are, given that there is this quince duty out there, taking a whole lot of steps. And you might ask, well, what's a reasonable bank doing? It's all beside the point if the duty is wrong in the first place. There's nothing intrinsic in saying, well, this is what a reasonable banker should do. You've got to know what the duty is in the first place. And the only safe assumption a bank can make is that time is of the essence to its customer. Certainly, a test which requires a bank to ponder, A, whether it has quite enough grounds for suspicion, and B, whether other banks would or would not abide by an instruction, is unhelpful for both banks and customers. This is not to deny that for agents who do have discretion, what is required will vary with the case. I've already made that point. Okay, let's turn to the New Zealand Supreme Court decision in Westpac and MAP, which applies an earlier decision of the New Zealand Court of Appeal, which reached much the same conclusion. And I've said on this slide, Westpac shows one side of the coin. And this is the side, if you think back to the two questions I posed, the answers to which should go together, relates to the first of those questions. What if it looks as if the mandatory is being dishonest and the bank therefore refuses to follow the mandatory's instructions, and it turns out that the mandatory was honest after all, the bank was wrong, and the customer has lost a business deal? Is the bank liable if it had reasonable grounds for suspecting that there was dishonesty? And the New Zealand Supreme Court says, yes, the bank is liable. If it turns out, despite the reasonableness, that the mandatory was honest, then the bank is liable for any losses the customer suffers. And so, quote from the judgment, the starting point for resolving the issue must be that as a matter of contract, a bank's clear initial duty is to act in terms of its customers' instructions. Too ready or easy an undermining of that obligation would introduce much inconvenience and uncertainty into a fundamental commercial relationship. Quincecare is footnoted only, literally, by the Supreme Court in Westpac and MAP, and the court doesn't really notice that the cases are close to irreconcilable, the other side of the coin. In the Westpac case, one should note that there was no reason for thinking that the customer's direct personnel were dishonest, but there was good reason for thinking that the customer's own clients were dishonest. And the reasoning in the New Zealand Supreme Court is pretty clear that if the dishonesty had been thought to be in the actual signatory on the bank account, the bank would still have been liable. The facts of Westpac and MAP are really quite dramatic, insofar as the bank's grounds for not making this payment seem to me to have been incredibly strong. Many of you will know the case, but I think it's probably worth, for those who don't know it, having a brief outline of the facts. And these are taken from my article. The claimant, the respondent on appeal, was a firm of accountants based in the for those of you who aren't New Zealanders, provincial New Zealand city of Hamilton. It asked a local branch of the defendant bank, Westpac, to hold interest-free some US 49 million that the claimant was receiving on behalf of a South American client. The monies were understood to relate and did relate to the sale of the majority shareholding in a private Bolivian bank to a state-owned bank in Venezuela. Apparently, the sole explanation given Westpac for using a New Zealand bank was that the president of Venezuela was not very fond of the USA and he would like to use an independent bank, unquote. This was scarcely a credible explanation for using the provincial branch of a New Zealand bank. The claimant was not an existing customer of Westpac, but nonetheless, Westpac agreed to act on its instructions, which were given to the bank in a sealed envelope with a command not to open it until instructed. The bank was also told that it was likely that it would receive those instructions within a week or so. As it happened, it took 13 months for the instructions to arrive. In the course of that period, Westpac's compliance department had received a notice alerting the New Zealand banking community to large payments being made from Bolivia and the need to treat these with caution. The claimant had also asked the defendant, the bank, to act in another transaction for the same South American client in the sum of US 1.3 billion, which the provincial branch decided was too big for it to handle, and it declined to assist with that one. Towards the end of the 13 months, the defendant was informed that the Venezuelan bank had assigned its rights to another state-owned bank, and a fresh set of instructions were supplied, again in a sealed envelope. But then, shortly before the instruction to disperse was given, the original Venezuelan bank, which was not directly a Westpac customer, communicated with the bank from New York and indicated that the sale agreement had been cancelled and that the monies in the account should not be paid out. Westpac started to make inquiries of its own about some of the individuals in the Americas, which had some contact information, which did not give it any comfort. In particular, the bank was told that there was to be a change in the beneficiaries of certain escrow arrangements from those notified a year earlier, and that the change had been approved by escrow agents in Panama, a suspect jurisdiction at the time. When the instructions finally came, again from the New York branch of the Venezuelan bank, the bank declined to follow them and invited its customer to get a court order. That the claimant duly did, and it sued in this litigation, claiming losses and costs, and the New Zealand Supreme Court said that the bank should have made the payments. It was its job to make those payments, and if the agents turned out to be honest, then they had no excuse for not having made them. So I think it's a fairly, as I say on the slide, the facts of Westpac and Matt are fantastic. Unfortunately, the case was not cited to the UK Supreme Court in Singularis, which affirmed the Quincecare duty in England, although the duty was conceded by the bank in that case. But it does provide a graphic contrast, I think, to Singularis. Singularis involved the draining of $204 million from one company and a group of companies when the group got into a situation of insolvency. And so there was a payment of the sum from the plaintiff company to another company wholly owned by the same shareholder, Mr. Al-Sanaya. Something seems to have been made in this case by the courts of the fact that the payee company was not in the same group. For myself, I don't understand that point. They were wholly owned by the same shareholder, beneficially owned by the same shareholder. In my view, they are in the same group. There's no legal basis for distinguishing from any other group situation. The Court of Appeal in this case, paragraph 98, Mr. Justice Voss, the Chancellor as he then was, he's now Master of the Rolls, he pointed out that it was the first successful Quincecare case, and he said it will be a rare situation for a bank to be put on inquiry. There is a high threshold. This case is therefore an unusual one, the circumstances of which are unlikely often to arise. Well, as I say on the slide, yeah, right. Actually, this was just at bottom, in my view, a routine intra-group transfer between companies in financial difficulty. Insolvency does not terminate the director's power to continue to trade and operate bank accounts, nor does it stop the director's power to make intercompany transfers, or indeed to reimburse themselves for expenditure they may have incurred on behalf of the company. Contrary to Mrs. Justice Rose, who was the judge at first instance in Singularis, and I should say the bank lost at all three levels, contrary to Mrs. Justice Rose's view, it was irrelevant in my view that the Daiwa bank was not a retail bank and had only a modest number of customers. This has nothing, in my view, to bear on the question. The instructions of the customers of a small boutique bank are just as important to them as any other bank's customers. And none of the factors listed by Lady Hale as notable, in other words, as being significant, such that the bank should have not paid out, were, in my view, very notable. The bank knew the group of companies was in financial difficulty, but that's common, and suspicion is not knowledge. The bank was given inconsistent reasons for the movement of the funds around the group. But in my view, since a customer has no duty to explain and the bank has no duty to ask, only suspicion could be raised by that. Next, the court said that the bank should have been put on inquiry to the fact that the account was totally drained of this very large sum. But the draining took place in 8 steps. And as I say on this slide, in my view, and the law should be that money is there to be withdrawn and the account is there to be closed. Again, the sums were very large, but then the group had dealt in huge sums. The company's largest creditor, Lehman Brothers, had security, mortgage security for $1.3 billion US of credit. And that security it realized after the insolvency, and its ultimate loss was only $144 million. Not a small sum, but relatively speaking, this company dealt in huge sums. So the basic problem is that there's no moral or legal basis, in my view, for expecting banks to undertake a monitoring role, at least in relation to a commercial customer. And there are huge forensic costs. One only has to read the judgments at all 3 levels in this case to see the forensic complexity that took place in deciding the case. The conduct of individual staff members and their competence, not their honesty, was gone over with a fine-tooth comb, all backed by expert evidence as to what other banks would do. The so-called very rare situation was followed by another major case within 2 years. And as we'll see shortly, the Quincecare duty is on the loose. So Mr. Justice Foss's prediction was pretty obviously going to be wrong, and it's proven wrong. In this second case, the Morgan Chase and the Republic of Nigeria, again, huge sums are involved. And again, very senior personnel were said to be alleged to be dishonest. It was a strikeout proceeding, so we don't know the full facts, haven't been fully determined. But the bank was supposed to be monitoring these very senior mandatories, one of whom included a government minister. So the 2 mandatories on the account that could operate the account were the Minister of Finance and a person called the Accountant General. And it was alleged that these 2 were dishonest and that corruption had reached into the highest levels of the Nigerian state. Well, you know, I ask, well, who were the bank supposed to inquire of in this situation? In the case here, again, the existence of the duty was conceded by the bank for the purposes of the strikeout, and the case focuses in the Court of Appeal on a raft of exclusion clauses in the bank's contract with the customer. And the Court of Appeal goes through these exclusion clauses one by one and ruthlessly finds an excuse to not give effect to them. Except one, actually. The court repeats the endorsement of the relevance of money laundering legislation from Singularis in this case. The judge at first instance in the Nigeria case was one Mr. Andrew Burrows QC, then a professor at Oxford and now elevated to the Supreme Court. He gave the judgment at first instance, and he said at paragraph 40, to recognise such a duty of inquiry would be in line with sound policy. In the fight to combat fraud, banks with the relevant reasonable grounds for belief should not sit back and do nothing. Well, in my view, and we may have time at question time for discussing what's the relevance of anti-money laundering legislation, but it begs the question of the cost-benefit analysis of money laundering legislation. Judges don't know whether money laundering legislation might be repealed in 10 years' time because it's causing so much inconvenience to honest people all around the world. The common law, in my view, is there to provide a minimum regime, not to be the hand-servant action person of Parliament. It's rather pointless, too, to be thinking about these public policy arguments when, if it's accepted, as the courts have, that a bank can contract out of the duty. well, really and truly, in my view, this is a red herring. Since Nigeria, there have been at least three English cases. I've put two of them here on this slide, and there's been one very recent decision in New Zealand, where, again, it was a strikeout in the New Zealand case, and the relevance of Westpac and MAP is noted, and it's going, at a full hearing, the court will have to consider what is the interrelationship between the New Zealand Supreme Court decision and MAP Associates and Singularis. But in the Stanford Bank case, the Stanford International Bank case, this was another case where there was really no one to inquire of. The whole company's business was running a Ponzi scheme. The bank was supposed to have worked this out and have frozen the customers' funds. And this plea was attempted to be struck out, and it wasn't. And then in Philip and Barclays Bank, however, a judge at first instance has decided that Quincecare should not be extended to cases where it's not a dishonest mandatory that's involved, but the customer is simply duped by some scammer or other external third party. So in this case, the very customer has made the payment but has been defrauded, and the judge said, well, Quincecare is a different fact pattern, and we shouldn't just assume that banks are supposed to protect customers against their own being defrauded by external parties. Tandem Group is a bit the same. It's really perhaps a compromise. Here, the actual authorizer of the payment from the account was the very customer, a human customer, but she was scammed not by an external party, but by her own accountant to write a check in favour of the Inland Revenue Department. The dishonest accountant, then said, "Well, actually, I'm not sure that the Inland Revenue Department is the correct payee. So please sign again above the payee, and I'll put in the correct name of the payee." Which, of course, he did as himself. I don't think he even disguised his name. He just put his own name, and the bank met the check and now is being sued for not having gone back with this check, with the endorsement and change, going back to check on with the customer. Again, this is strikeout only, and the judge refused to strike it out, saying that the duties of care will have to be decided at a full trial, and acknowledging that the Singularis line of cases could well be followed in New Zealand when the New Zealand courts get to fully consider them. That's fairly all the major part of the talk. I just want in this last slide to say a few things about personal consumer customers, which was the case in the Tandem case. The general argumentation that I make in the article is premised on the position of commercial parties, and that's the pattern of the three leading cases, Quincecare, Singularis, and Nigeria. And in my view, there's no place for implied terms here as an addition to the duty to just pay on the instructions of the people you're told to pay on, whose instructions you're told to pay out on. The article also focuses on fact patterns where the dishonesty is in those personnel. It doesn't address cases of external scamming. And obviously that is, I think, a different question. There's also a different question if the bank finds that the person who operated, say, a PIN on an account has absolutely no authority at all, but has somehow got hold of it extraneously. Those cases are different also because there, and technically, the bank has acted on effectively the instructions of somebody who has no authority at all. And that then raises the question about whether customers have a duty of care to the bank to keep their PINs safe. So it's a different issue, a different set of issues, obviously related, but I'm not addressing them in the article. Of course, in consumer transactions, the banks may voluntarily assume a responsibility. And if you do that, then the law of tort, at least, and arguably the law of contract, would say, well, if the banks are happy to pick up this monitoring task, then the courts are then entitled, in my view, to hold the banks liable. But until that's done, and until it's, unless that's clear, in my view, the court should not be implying the duty. Well, of course, Parliament, as part of consumer protection, may impose a duty to warn of unusual activity on banks. The costs will be passed on by the banks. That's fine, part of consumer law. And of course, there's also room too in consumer situations, for more informal dispute resolution mechanisms to be used, as is the case in many Commonwealth jurisdictions, including New Zealand, of the use of banking ombudsmen, who can, one way or another, take a more benign view of things in favour of customers. That's part of the process. But this talk is really about the default rule for commercial parties, which is what this modern case law is about, and I think it has entirely gone off the rails. So, Helen, I think that's the end of the slides. And I don't know whether you've had questions come in, but we can open it up for questions now. I'll just stop the share.
Oh, Peter, we don't have questions, but in fact, I did have a question about coherence in the law, which effectively you've covered. So I just want to ask you one other question, which is, given that we have a number of these Quincecare cases emerging through the courts, do you think there's a real chance that the UK courts will actually revisit the jurisprudence in this area? And I'm just sort of thinking about the going off the rail with the dishonest assistance test that we saw with Quincecare after TAN. Is there, do you think, a real chance that actually the Quincecare duty might effectively die away because it's jurisprudentially wrong?
Well, it won't die away, but it might get killed. I haven't given up hope. The whole point of my Journal of Business Law article was to try and effect a further appeal to the Supreme Court in the Nigeria case. That hasn't taken place. They've decided not to appeal and to raise the issue at trial. I'm told it's being argued for the bank. It's being has counsel at my own chambers in London, Fountain Court. I'm not involved with that case, but I do know that at trial the duty will be put in issue for. It'll have to probably be at least a Court of Appeal level. It may have to be held until Supreme Court level, but they will, I think, argue it. And I think there not only in my view are the merits in favour of it, but as I said, but may not have made completely clear, the duty was conceded in Singularis. And although the court, Lady Hale in particular, and the Supreme Court thought that concession was right, it was a concession. It was a conceded duty. So it wasn't fully argued.
Yeah.
That says a bit about English, the strategy in the case, in my view, but it wasn't fully argued. And so that's a reason why the Supreme Court cannot simply assume that they're going to have to use the practice statement. They don't have to use the practice statement to overrule Singularis because the point was conceded. So yes, I'm hopeful that it will be reviewed. And of course, as an academic, still an academic of a sort, I'm hopeful that I might get some credit if it is reviewed. But that's the whole point of the article. I have mixed success on that. I seem to have more success in England than New Zealand, and occasionally I've had great success with England. But my rhetorical style sometimes is possibly the kiss of death. But anyway, we'll wait and see.
But well, given that we have got Westpac and MAP in New Zealand, perhaps your argument might receive better treatment before the New Zealand courts, and this might be a situation where the New Zealand courts lead the jurisprudence.
Yes, in the tandem case, I had no input in that case either. I was unaware of it until counsel told me about the judgment. I haven't asked him whether he cited my article, but the judge certainly refers to the article and notes the contest. So for strikeout purposes, she wasn't prepared. Justice Katz wasn't prepared to get into the argument, but she's noted it. And yes, certainly Westpac and MAP, I think, is problematic. Although the Supreme Court and Westpac and MAP itself didn't seem to notice the problem, it is a problematic thing to try and reconcile the two. So yes, I am hopeful that New Zealand will say, well, Singularis, the English can keep, the UK can keep it. We're not going down that route.
We have got a question here, Peter, which I'm not sure if you can see, but I can read out. So the question is, I think what you are saying is that there shouldn't be a negligence duty on banks. We are seeing negligence claims coming through from customers of the bank's customers, fraudulent trustees. What are your views on this?
From customers of the bank's customers.
Customers. So yeah, and then it's fraudulent trustees. Yeah,
I think the law is reasonably clear if this is what this question refers to. I'm answering live. Is this all right? Can you hear me talk?
Yes.
Yeah, I think what this question might be referring to is when is a bank liable for not having stopped this is effectively the scamming situation, a fraud by somebody else on the bank's customer, or a fraud, a bank's customer is a trustee, and the trustee is being dishonest on the beneficiaries of the trust. The general rule there is that you do need a dishonesty test. This is dishonest assistance. And I think a bank would only be liable to the beneficiaries of the trust if the trustee's the person who's got authority to operate the bank accounts. Then they are the trustee, they are the appropriate person. Then it's arguable, at least, that a dishonesty test would follow from the dishonest assistance test. Of course, if the money is then used to pay off somebody's overdraft with the bank, then you might be in knowing receipt, and you would be back, at least in New Zealand law, to something like a negligence test. So where a bank, this is something I discuss in the article, where a bank is actually not just acting on its customers' instructions, but is actually directly benefiting from the payment, then a duty to inquire can certainly arise.
Thank you, Peter. We don't have any more questions, so I will take this opportunity to thank you, Peter, on behalf of the BFSLA for your lecture today, which has shone light on what is actually a very complex area of the law, but one which is at the heart of banking business. I'd also like to say how fortunate we are, Peter, to have you on the academic committee. So I will draw the session to a close, and thank you to everybody for attending.